It's a great pleasure to have John D. Honsberger here to give you a lecture on commercial reorganizations. John Honsberger is an author of bankruptcy law in Canada way back when. 1970 was one of the editions. He was one of the authors of the Tassé report that I referred to earlier in 1970 on bankruptcy reform. John is a frequent contributor to the Law Society of Upper Canada on programs, as well as the editor of the Law Society Gazette and for the Canadian Bar Association as well. And John is also an author of a new book on debt restructuring in Canada that covers not only proposals but also the provisions under the CCAA and other techniques. And he is most eminently qualified to deliver a lecture to you this morning on commercial reorganizations. John?
Thank you very much, Frank. I certainly commend you and Aubrey and the continuing legal education departments of both of the Law Society and the Bar Association for putting this program together. I think the presence of so many of you here this morning reflects your interest and concern in the state of bankruptcy legislation in Canada. I hope, however, you won't go away thinking that the millennium has come. And I may, perhaps a moment to kind of introduce what I want to say by discussing perhaps my bias to the approach. And I know you've heard the other point of view already this morning. I have been working for 30 years on the, commencing the Tassé report, and at the end of 30 years, we've got C-22. And I'm told that we should be happy to have this and should not expect anything more. But I find it very embarrassing going around I was going to say the world, but you go to other countries and you ask what we have, and well, first of all, we say, well, we got a Bankruptcy Act, we got a Winding Up Act, we got a Company Creditors Arrangement Act, we've got a Farm Debt Review Act, we still have the Exchequer Court Act alive for one paragraph, for railroad reorganizations, we've got the Federal Insurance Act, the Federal Trust Companies Act. Now it's a board game. Where do we start? And we get in real trouble if you pick the wrong statute. I'm also, we have a very interesting situation now in respect of consumers. We now have consumer proposals that apply to all provinces, and we have Part 10 that applies to 5 provinces. We don't have that concern here in Ontario, but the rest of the country, it must be kind of interesting. I've written a little thing on this, is that when you get a consumer come in and you say, what do? We'll have a Part 10, or well, we have one of these new C-22 proposals. But I say, this is the situation of our Canadian insolvency law after we've been studying it for 30 years. I suggest that we have the most, I better be careful, but every other country in the Western world has had complete new bankruptcies acts in the last 25 years. France has had 2 major bankruptcy acts in the last 15 years. Germany has a new one. Ireland, Australia, England, United States has had 1.5 since 1978, and we have C-22. I was saying, Frank, that I'm in the process of making an affidavit in my office describing Canadian law for an English creditor who is commencing winding up proceedings against a debtor in England. And they have assets in Canada. What is the law, or the Canadian law, for the recognition of a UK winding up order? I find I'm embarrassed. I feel almost like a country cousin because I got to come along and say we have no statutes. When I wrote 2 years ago suggesting that we should have some conflict of law provisions put into C-22, they said, no, that will go in phase 2. Once phase 2, nobody knows. But here we have, in the common law provinces, we have a lot of rules that are being put together in old cases. Quebec, almost no rules. And here you have to write to these English people over there and saying that we seem to be about the only Western country, and I add Australia in that don't have any provisions for conflict of law rules. So really all I am suggesting, as I say, I don't want to say more, but I really think the suggestion has been made that we're going to have a review of the C-22 in 3 years. I really think we all should try to get together and not rest on the laurels of what we have, but I think we should really work hard now for a 3-year review to get something. I think we should establish a philosophy of insolvency and debt restructuring. What is our philosophy? It's kind of interesting is that France has been running scared with the EEC. They've had 2 major bankruptcy acts in the last 10 years, and their real concern is that being in the EEC, that they are afraid of losing French jobs to the Germans and everybody else. And that is what really has moved the French. They now have a new act that you start off with something like a notice of intention saying you're insolvent. You go to the bankruptcy judge, the juge commissioner, and he gives you a 1-year moratorium. And then during that time, he sits down with you, with the company, and works out a plan and so on, and has meetings with creditors. And then when they have the hearing, only creditors who represent at least 15% of the total claims can even turn up in the courtroom. That's it. They only want the big players, but their big concern is the jobs. And I'm wondering, with our bilateral trade agreement with the United States and the one coming up in Mexico, whether we should not be thinking the same way. On the other hand, the Germans have just come in with a brand new bankruptcy. Well, it's still a bill. They've been working on 8 years, and they've just taken the very opposite view. A creditor makes a deal that so much is to be paid in certain times and certain security. That goes. The debtor goes down. We only have so many resources, both physical and financial, and we can't have these weak debtors around. If they fail, they go down. And they have just the opposite philosophy of the French. And I sometimes have thought that we could have an interesting discussion to have a comparative law meeting on the German and the French philosophies of reorganization, and then try to say, what is a Canadian one? And obviously with C-22, we're getting more towards the protecting debtors, but that is only by way of introduction. I was told I should not stick too closely to my printed paper, and I should also say about that paper, I think it was written in December, I have made certain comments in there. As you all know, the bill is kind of a moving target, and you should not take everything I have said as being what will be in the bill. It was in the bill as I saw it, but there have been many changes, so I do caution you whenever I say anything in the paper, it may not be when the bill is finally enacted. But maybe I should now start, after commencement of proceedings. And I say, now in commencement of proceedings, we do have to sit down and say, what statute are we going to use? Being an urban area, well, you're not all urban area, but we get the Farm Debt Review Act, the winding up back for certain cases, and the Bankruptcy Act and the CCAA. But when you decide what statute you're going to work in, I assume that we've now decided we're going to work under the proposal section of the Bankruptcy Act. I suggest, however, is that once we have decided that we're going to use the proposal sections, we then should sit down and decide which procedure are we going to use. And I suggest, there's the first alternative we have is what we've been doing since 1949, and that is to file a proposal up front as the Act requires. We have been doing that for a long time, and I suggest in most small or medium-sized insolvencies, we have been doing it. Why should not we continue to do it? Because I'm a great believer is that the real losses are often from the time that you commence reorganization proceedings, particularly if you have long stays. And there's some advantages in using the present system. The next way we have is now we are given the well, I should also say we can move, the second procedure is the holding proposal, a definitive proposal, and that works well for the bigger ones that we really can't put a plan together, and there's some advantages in doing that. And then the third way is a new way by filing the notice of intention. I should say, by way of background, the notice of intention was first contained in that Tasse report. And of course, the Tasse report was before the 1978 Bankruptcy Code of the United States. It was before we had our holding proposals approved by Mr. Justice Holden. My own feeling is that perhaps we don't need the notice of intention. We get along quite well with the interim proposals. I have a concern too is that speaking for myself as an example, it's very easy to be lazy. When we have an opportunity of being lazy, we start by filing a notice of intention instead of what we have to so often do, stay up half the night and get things done very fast because we know that the bank's not going to honor the payroll on Friday, and we work and get it done. I'm afraid now is that when we're all very busy, we file out these notices of intentions. At the end of 30 days, we still haven't really got down to it, and we go up and ask for an extension. And I think it is really something to look out for. I think it is bad for the debtor because if it's going to fail, they might as well fail fast. It's bad for the creditors because the real losses are after you file when the debtor starts cannibalizing itself. So I just suggest is that I would, and I know I will do it, look at myself and I say when I'm filing a notice of intention, am I just being lazy or should I get down and do it? I wonder too, notice of intention is that, again, is that so often these proposals, we have to make a proposal at the last minute, and you do it, but how long is it going to take to make this notice of intention? First of all, we have to have the name of the trustee. That's easy enough. You get the trustee. And then we've got to list all of the creditors who are owed over $250. And if the debtor doesn't have his affairs in order, how long is it going to take that? And then and I don't know whether there's any change in this, I hope there's a change, is that we have to file a cash flow statement. The debtor hasn't paid his accountant for a year and a half. The accountant still has his books with him, and you go and say, I want the books to prepare a cash flow statement, and the accountant will say, well, pay me. And, you'll get them, but it might take 4 or 5 days or a week to get those books. Meanwhile, the debtor's going crazy, the sheriff's knocking on the door, and they say, we can't file a notice of intentions until we get a cash flow statement. So have we really gone very much farther ahead? Couldn't we just have filed a proposal at the same time? But look out for that. There may be changes. The cash flow statement certainly makes sense if you could send it out with the notice of the first meeting. It certainly helps the creditors to decide whether this is a viable concern or not. And I think that is a good idea to have it to send out with and many trustees in effect send that out. But the idea that one has to prepare this on Friday afternoon, but it should also say that it says there's going to be regulations, and the regulations might make it a lot easier than what it says. But I ask you, how long do you think it's going to last? And then we know that this notice of intention can be extended up to a maximum of 6 months. I suggested one of the things that we are going to have to change our practice. Our practice has really been a debtor-motivated practice. The debtor's filing proposals, we are moving fast, we file, we have first meeting of creditors, we're up into the court. Everything up to now has been based on getting into court and getting out fast, something like the English system. Now when we're moving more towards the American system, I think we have to be more either creditor-oriented, but creditor-conscious. And I think creditors have, if those of you acting for creditors have to be practiced differently, because you know that you might have a 6-month stay, and I think when you're negotiating reorganizations with debtors, you want early notice if they're going to file. You want to be ready to move into court, the next day, and saying that the stay should not apply to me. The stay applies to everything the debtor owns, but if the debtor doesn't need a certain asset, should the stay apply? I will talk about the problem of the stays with utilities, but you know how long it takes to get into court, and I think we should, working for creditors, we should be ready to move fast and ready to make effective presentations when the debtor asks for a stay. That's another thing. I'm reading C-22. It doesn't say whether the stay will be extended on an ex parte application or whether it has to be on notice. But again, the new bill may clear that up. But again, I suggest is that when you're working with the debtor, you get his commitment that if he's going up to ask for a stay, that at least you get 24 hours notice so you can be up there. But I just point that out. I think we should be conscious of the problems with debtors, because, look what is happening. The debtor is continuing to use the creditor's assets. You've got a fleet of gravel trucks, and they're worth so much today. They are worth a lot less in 6 months' time if they've been on the road 15 hours a day, and all these other situations. Meanwhile, interest is building up, and I think creditors have to be much more active than they have been. And we're seeing this, of course, in the CCAA. Originally, you filed your plan and asked for a date for the meeting. And now we go to court under a new procedure, and the court will say you give you 5 months. And the creditors are now beginning to learn under the CCAA is that it is a new game. They are going to be hurt during this stay and are being hurt, and creditors under the CCAA are being much more aggressive with due reason. And I suggested that we have to look at what's been happening in the CCAA and be prepared to move fast in these new proposal sections. But then the next thing I want to talk about, the stay. One thing that bothers me about the notice of intention is that once the notice of intention is filed, first of all, the trustee must monitor the debtor's business and financial affairs until the proposal is filed or the debtor becomes bankrupt. So here you've got a monitor looking over the debtor's shoulder. He must also report as prescribed to the creditors. And what bothers me more, he must participate in the preparation of the proposal and shall advise and assist the insolvent person in that regard. And when I look at that and I say, whose proposal is this? I mean, is it the debtor's proposal or is it the trustee's proposal? And I don't mind it being the trustees. I'll tell you how they do in England. But if any of us lawyers in here wore so many hats, we either be trouble in the Law Society or we would be in court, and no amount of Chinese walls would protect us. But it does seem to me a little strange to put trustees by statute into this position where they can almost do better by making a poor proposal that's going to fail, because they'll make a lot more money in fees in a bankruptcy. So my feeling is that if the debtor's going to make the proposal, the debtor should make it. And I say that is one more reason for proceeding under the present way. Forget about the notice of intention and proceed the other way. At least it's the debtor's proposal. He'll be working with the trustee, as we always do, but it is his proposal. So I just point that out. If you've got a debtor that you are concerned about, you don't want too many people looking over your shoulder, think what you are getting into it. And again, be careful and look what the bill looks like when it's finished. But as it's now written, with a notice of intention, you have a compulsory, the trustee must monitor, must make reports, and must participate in the preparation. And what that means, I don't know, must participate. But I point that out to you, and I suggest it's not a very good idea, but I'm all in favor of the trustees doing it. And if I could just digress a moment, some of you may know of the English administration proceedings, which I think is a better system than ours or Chapter 11. Under the English administration proceedings, once administration is order, administrator, who is a trustee, goes in, he assumes all of the responsibilities of the directors and management. He's got 3 months to to run the business for 3 months, look at it, and at the end of 3 months, the statute said he must call a meeting of creditors and present proposals, plural. Not one proposal, and it might be, I think we could sell off this division, I think we could do this, I think we could do that, and comes up 3 proposals, say. The creditors cannot make any other suggestions, but then the creditors must vote on one of these proposals that the trustee presents. I think that's not a bad way. Our way, it's a kind of a debtor's proposal. The debtor looks at his affairs with rosy glasses. The American proposal, which tends, American Chapter 11, which tends to be more creditor-oriented, and you get a creditor proposal. But at least the English one is a straightforward business type of approach where the trustee does everything. And when we get down to the 3-year review, maybe we might look at the English model. But I say whatever model we use, it should be a clean one. The debtor does it, or the trustee does it. And I was going to say the effect of filing a notice of intention by an insolvent debtor is that no creditor, defined by the Act to mean a person having a claim, preferred, secured, unsecured, provable under that, has any remedy against the insolvent person or his property, and may not commence or continue any action, execution, or other proceeding for the recovery of the claim. The debtor may continue to use the trucks. The stay, however, does not apply to a secured creditor has moved and taken possession before the stay commences. I have referred to a lot of this in my paper. I say it is to be noted that the provision for the automatic stay does not make any distinction between assets of a debtor which may be necessary for the debtor to make a successful proposal and assets that may not be needed for such purposes. However, the court may take this distinction into consideration when requested by a creditor to lift or vary a stay. The court may also take into consideration whether or not a secured creditor is adequately secured or undersecured, which would indicate whether the creditor, in the terms of Bill C-22, is significantly prejudiced by the continuance of the stay when considering the right of a debtor to continue to use or deal with the secured assets. The court may also lift or vary the stay when there is evidence of bad faith on the part of a debtor. For example, when proceedings were commenced by a debtor in reasonable financial health, you still have to be insolvent, but only technically and marginally insolvent to permit the use of Part 11 of the Act to avoid pending litigation. And I think we got to be aware now that now we have a statutory provision for good faith, like in Chapter 11, and there have been several cases under Chapter 11 where the petition has been set aside because of alleged lack of good faith, that they were just trying to avoid something. Notwithstanding, under Chapter 11, you don't have to be insolvent, but you have to file in good faith. And we now have this good faith with the notice of intention. And I think, again, we look at that good faith when we are preparing to argue against the extension of the stay. I've talked about the role and the duties of the trustee. I should also say the trustee must sign the cash flow statement, so that here you are required to make this cash flow statement, but the trustee must sign it. I'm sure that there must be changes in the final version, but if you have to do everything that C-22 says, that I'd be scared stiff that everything had gone by the time you could file. You know, thinking that it could easily take a minimum of maybe 48 hours or a week or so to get all this stuff together. I've talked about the strange position of a trustee with a statutory conflict of interest. I next want to talk a little bit about classification of creditors, which is an important thing. A proposal must be made to the creditors generally, either as a mass or separated into classes as provided in the proposal, and may also be made to secured creditors in respect of any class or classes of secured claims. However, where a proposal is made to one or more secured creditors in respect of secured claims of a particular class, the proposal must be made to all secured creditors in respect of the secured claim of that class. Now we get down to what I'm concerned about. Secured creditors are in the same class if A, they are secured against the same assets and rank at the same level. They are secured against the same assets and rank at the same level, or B, and this is what I'm interested, meet the prescribed criteria. The definition, to my mind, is very narrow and restrictive, presumably based on the principle of identity of interest. The Ontario Court of Appeal recently in the Nova Metal case said that there should be a true community of interest among all members of a class. This is sometimes called the commonality of interest. In New West and Karma and even Dayon, these are CCAA cases, a whole package of mortgagees and were all put into a single class. The Penn Central Railway case in the United States, every mile or two of the railroad track had different creditors. They were all put into large classes. I suggest, unless the regulations, when prescribed, otherwise permit it, each secured creditor will constitute a single class unless there are others who have a charge in the same assets and have the same rank or priority, such as joint mortgagees. It is one thing to say that there should be a true community of interest. You've got to be exactly the same among all members of the class, and to say the interests of each member of the class must be identical. If that's the case, we have not moved one step forward. Because if you have 5 secured creditors, you can't put them in a class unless they're joint mortgagees. You have a first mortgagee, a second mortgagee, you have the bank and whatnot. They are all separate classes, and you've got to negotiate. You've got to put them in each separate class, and they can a class of one can vote against it. And I think we've got to look at that if the parliamentary committee has not done so, because the way I read it is that, you know, classes of secured creditors is a great idea in principle, and certainly we've seen it work well in the CCAA, and the courts have been diligent in making sure that you don't bring in oddball claims like tax claims or something in making the classes. But we certainly have just put only the tip of one's toe into the water in this question of classifications to say that, yes, we can have classifications and classifications of secured creditors, and we say, gee, isn't this great? We are really moving ahead. We're just like Chapter 11. But then when they come around to say that they have to be secured against the same assets and rank at the same level, it's all smoke and mirrors, I think. But again, be careful to look at the bill to see whether there's any changes. And of course, what seems to be very important too are these regulations that are going to come along with it, and we may learn a lot from the regulations. I mentioned about proposals of employers. That's changed considerably with the taking that one part out of the act. The big thing is, one big improvement we have, of course, in proposal is the disclaimer on leases. It's, however, applied only to a proposal being made by a tenant and not by the landlord. A tenant can propose a proposal of a tenant can have the leases disclaimed, but a proposal of a landlord cannot. And but they're both executory contracts, but we make a distinction. Let me think of an example. Is that if a landlord was, well, if a debtor was really being pressed. Well, it does not also call, we can't disclaim labor agreements either, as we can in the United States. And look what happens so often when a debtor is being pressed. The union is pressing him, there's a strike, he can't afford a strike, so he makes a sweetheart deal with the union, paying much more than he can. He then comes along and he's got property. He rents a factory, or he rents pieces of property, whatever he has, but he rents it at half the market rate to get a year's rent front. But you know, whatever these desperate things that a debtor will do, we only have the one situation that we can disclaim, and that is of a tenant. But as I say, if a debtor trying to get immediate cash rents it at half price, he can't come back and say, I can't continue on that basis. The labor agreements, I think we've also got to look at, because so often that happens is that we really can't proceed with a proposal if we have to live with that labor agreement that we were forced to take 6 months ago. So I think that's another thing when we are all studying this for the 3-year review. Let's look at the experience of the Americans on these labor agreements, and we may be able to get something in 3 years' time. But you've probably seen the bill is that that one can now disclaim leases, and to my mind this is really essential for most reorganizations. Here, Jerry up here would agree with me, and so often the usual type of a restructuring is to shrink it down. If it's got 10 stores, you want to get rid of 5 leases and you shrink it down. But under our present system, you can't do it in a proposal. You've got to go into a bankruptcy. But at least this will permit us to use that basic approach of shrinking down an operation by being able to disclaim leases. I'm not sure whether that they've come up with the right amount. You know, we have the payment for disclaiming the lease is that amount equal to 6 months rent under the lease and the rent for the remainder of the lease, whichever is less. 6 months rent is quite a bit. I suppose if you're a landlord, and these times, you'd say, what's wrong with 6 months, because I can't rent the place in any event. But in normal times, I don't know, but that's a judgment call. But I think, again, you look at that. Again, we perhaps look at our experience of it, but you don't disclaim a lease frivolously, knowing that you can be forced to pay up to 6 months' rent. Think about that and gather statistics, and we may be able to come back in 3 years' time and, you know, make some change in that. And I do commend the government, you know, for introducing this provision. It's certainly a valuable and long overdue amendment to the Act. However, it only goes part of the way, as it does not permit the repudiation of other executory contracts, such as leases of personal property, licenses, franchises, supply agreements. I've also mentioned collective bargaining agreements, all of which are permitted under Chapter 11. I also, as a purist in language too, I also wonder why Ottawa came up with this funny word, repudiate. It's hardly a word of art. We already have disclaim and surrender. We know what disclaim and surrender mean. We have jurisprudence on disclaiming and surrendering. And now when we go into court and they say, well, there's nothing on repudiation, my lord, but we have cases on disclaimer and surrender. And I suppose one of these days, they'll, after several cases, they'll decide it all means the same. But what do we accomplish by inventing a new word? And I suggest that this was maybe not a good thing to bring in a word that there is not a word of art. But I think, again, that we should be looking at extending the disclaimer sections to all of these leases of personal property, licenses, franchises. Again, you know, if you're trying to put a debt restructuring together and you say, you know, I can't live with that license agreement, that franchise agreement. I just can't live with it. You know, that was all right when things were all right. And they say, well, you can just disclaim the lease on your building. And I said, I don't want to disclaim the lease, but I want to disclaim that agreement for my computers. But we can't do it, and we are all supposed to be very grateful with C-22. We now have disclaimers for land, but that's all. Again, it's another example of we're just really putting the tip of a toe into the water, and I guess you get so much criticism that's what we have. But again, I point out to you it's a tremendous improvement, but when we were working 15 or 20 years ago, the really only matters we had of concern were really of leases of land, buildings. And now we've gone so much farther in our financing that it's the personal property that is the important thing that we are leasing these days. And they are the real commitments. When I sign checks around our office and I look what I pay for the rent, and then I look what I pay for these computer people, and you know, again, I think that, you know, we're 25 years behind in making our step forward. This was good 25 years ago, but now it's the personal property leases that we really hurt and we really should be looking at. So again, I suggest that is something that we should be studying and not be bashful to make recommendations, and you know, maybe we will get it in the next round. Chairman of the first meeting of creditors. There's another change, and I think it's probably a good one. Under the present act, the trustee is the chairman of the first meeting of creditors. The bill now provides that the official receiver or the nominee will be the chairman, and any creditor may appeal any decision to the court. And I say it would be difficult for the trustee to appear as an impartial chairman, and I don't say at the moment we have the trustee as the chairman, but now with C-22, the trustee has prepared the proposal, He has advised the debtor. He's monitored every month and sent out reports. And I think this is this should be done, and it is done. I guess it really makes no great difference to our practice. Voting. Creditors voting on a proposal must vote by class according to the class of their respective claims. And I go back to your classifications. As I see it, we may have several classes of single creditors. They all have to rank the same. All unsecured claims constitute one class unless the proposal provides for more than one class of unsecured claim. And I think this is helpful. It follows the American procedure. We can say that all trade creditors are going to be paid in one class, and they're going to be 100 cents on the dollar at once, and other creditors can be done differently. I think that's an improvement. Secured creditors, in respect of whose secured claims the proposal was made, must vote before the unsecured creditors vote, which is kind of interesting. The unsecured creditors can, before they vote, can see whether the whole plan is being torpedoed by a major class of secured creditors who have voted against it. The majority required for approval of the proposal is a majority in numbers and 2/3 in value of the unsecured creditors at each class present personally or by proxy. Next thing I want to talk a little bit about utilities. The TASE report recommended the abolition of priority for municipal taxes, which included utility charges owing by a bankrupt where such taxes are not secured by real property. The report, and this is the TASE report, stated a municipality has the means to protect itself in the same way as do other creditors and should not be in the position to, in effect, require the creditors of a bankrupt taxpayer to pay the taxes that the taxpayer cannot. The report of the advisory committee in 1986 went further than the 70 report by recommending that a public utility should be prohibited from discriminating against a bankrupt or debtor who has filed a proposal under the Bankruptcy Act. This would mean that a utility could not cut its service for non-payment of charges while a customer is trying to rearrange a workout under the Bankruptcy Act with its creditors. C-22 has addressed the situation of the utilities, and it's kind of interesting. Definition of public utility has been introduced. The definition of a public utility is now in the Act. It includes, and note, it does not say means, but it includes a person or body who supplies fuel, water, electricity, or supplies telecommunications, garbage collection, pollution control, or post services. Does that cover a courier, for example? I wonder if a courier is a utility. It supplies some kind of a post services, garbage collection, and so on. But look at the fuel, water, electricity supplies, telecommunications. What's that? Is that just telex, or is it our fax machines? Garbage collection, pollution control, or post services. Again, I suggest when you go away and when we get the final version of the bill, we should look carefully at that definition, because we have a mindset of what we think a utility is, but now there is this definition of a utility, and you've got to be careful because it's not an all-inclusive definition, because it says it just includes these things. So it's up to any of you, and again, this be acting for a debtor, to be quite ingenious and creative and come up with a new kind of a utility and say, this is an important type of service that is provided, and it comes under the definition of a public utility. So debtors or creditors, look out for that definition. And then the other change is claims for debts or liabilities for goods supplied and necessaries for life will be treated as any other claims and will be released on the discharge of the debtor as the case of most any other claim. Now, certainly at the moment, if you're acting for a utility company, is that, particularly in the consumer debtors, is that they just wait for the discharge, and once the discharge comes along, they then go and try to collect from the householder, because they say that the electricity was a necessity of life. And to a certain extent, the utilities have not been hurt too much in that regard now, because they can, using that as a necessary of life, they can go and collect. Utility company will not be able to do that anymore. And again, if you're acting for a utility company or any of these people who in the past protected themselves as being good supplied for the necessaries of life, you've got to now be much more diligent. You've got to make sure that you don't get these debts building up to be wiped out on a bankruptcy. A new section limits the rights of a public utility to discontinue service when a debtor either files a notice of intention or makes a proposal, to make a proposal. So the utility cannot discontinue service, but then it's quite involved. It goes on to say, where a notice of intention or a proposal has been filed in respect of an insolvent person, no public utility may discontinue service to that insolvent person by reason only. Oh, I know another public utility, of course, the telephone company. That's telecommunications, I guess, so the telephone company is now a public utility. But getting back to this, that once a notice of intention is that they cannot discontinue service to that insolvent person by reason only that the insolvent person is insolvent, a notice of intention or a proposal has been filed in respect of the insolvent person, the insolvent person has not paid for services rendered or material provided before the filing of the notice of intention or proposal. Presumably, if they don't pay afterwards, you can discontinue. Nothing in these sections shall be construed as requiring the further supply of goods or services for other than payment in cash or the further advance of money or credit. The court may, on the application of a party to an agreement or by a public utility, declare that this section does not apply or applies only to the extent declared by the court, where the applicant satisfies the court that the operation of this section would likely cause a significant financial hardship. I have seen a little bit of the bills that accumulate for a hydro, for example, in a big manufacturing company, and it's very easy, I have seen, for a debtor to be in arrears for a couple of months or more for electrical charges, and it could be a couple $100,000 for a business that you owe North York Hydro. And then what concerns me there is that my creditor hat is that the debtor owes $200,000 for a utility. He goes makes a proposal. He must pay his current ones, payments, but certainly in my house, I think the electrical bill only comes every 2 months. And, the first one comes in 2 months later, and I've got another $100,000, and I just ignore that, or I can't do anything about it. And then I go for another month, that's only 60 days, and there's another $100,000. You're up to $400,000, and this act says that you can no longer go back and collect it. And you are just out. And of course, when the utility is out, it's you and I who are paying it, because that goes on to our taxes. I think that it's slightly outrageous. It's maybe all right for individual homeowners where bills are $100 a month or $150 a month, but when you can get these very large amounts, and then what we do have is that you can, of course, go and get it changed, but what I have done in my paper, I have referred to Section 366 of the U.S. Bankruptcy Code, and they have the same thing, but what they have done, they have imposed upon the debtor the responsibility of showing that they can pay, that they give adequate insurance, and that's usually a deposit. The American system is really exactly the same as ours, but at least it imposes upon the debtor to prove that he can pay when the bills come. So again, I think this is something that should be looked at. That I think we should use the American plan. Time has come. I have written more that you can read. Take everything I have said with a great grain of salt, because it may well be changed when the bill comes along. I'm pleased to have been here, and I'm looking forward to the next 3 years when we have the review committee. Thank you.
I want to thank you, John, for your very, very thoughtful comments. I think that your words show your very great depth of knowledge of our law and insolvency law across the world. It's one thing to just explain new provisions, and another thing to do a critical analysis. And we thank you very much for your words. It's now my pleasure to introduce to you David Stewart. David comes to us from the trustee side of the practice, and not from the lawyer side of the practice. David obtained his trustee and bankruptcy license in 1981. He's going to talk to us about consumer bankruptcies and consumer proposals, and I urge everybody to stick around, because late last night when I was reading this material, it struck me, one, that I think you're going to be in for an amusing discussion, but two, that we probably all may have to resort to its applications personally, those who are lucky enough to meet the threshold of debt. David is right now the Assistant Superintendent of Bankruptcy for the Hamilton Bankruptcy District, which includes all of Peel, Halton, Hamilton, Wentworth, Niagara, and Brant. He's been with the Office of the Superintendent since 1976 and has served as an official receiver in the Toronto area, and so he is well familiar with the area. He is a member of the Joint Committee on Bankruptcy, and since April 1991 has been working with the Legislative Review Directorate of Consumer and Corporate Affairs Canada as part of the team preparing the amendments to the Bankruptcy Act. David?
Welcome to the other end of the insolvency spectrum. I'll leave it to you to decide which end you think this speech is about. First of all, can you hear me? If you cannot hear me, please shout out. I'm not easily offended. In fact, it's one of the job requirements of being a federal public servant these days, not to be easily offended. Before I go too much further, let me just, first of all, I'd like to acknowledge that there were a number of people who helped me with my paper. I won't give you their names right now. However, if any of you actually read the paper and like it, see me over lunch and I'll tell you who helped me with it. On the other hand, if you read it and you don't like it, well, I'll take full responsibility for it. On my way here this morning, I must confess to being a little bit nervous about appearing before you. However, over the past couple of hours, I have relaxed somewhat, and I felt okay until about 2 minutes ago when it suddenly dawned on me that I may be the only non-lawyer in the whole room. Now, what does this mean? Well, first of all, no lawyer's jokes. Secondly, a question comes to mind. If I'm the only non-lawyer in the room, does this mean that I'm the only person in the room who is not your friend? It's supposed to be a big laugh. Come on now. Maybe there's somebody here who can give me an opinion on that? Okay, the other thing is that there should be a warning on the front page of my paper. Clearly, again, if you read it, you'll see that this is not a federal government document. It's my document. Don't confuse it with the official federal government policy. Okay, consumer insolvency. I like to think of it as a battle between the stereotypes. If this was a classroom, to illustrate the point, what I would do is as follows. Assuming there are 10 students in the class, what I would do is have 9 of the 10 students show up wearing t-shirts, jeans, old baseball caps, and sort of adopt a general hangdog expression on their faces for the length of the class. For the 10th student in the class, I would have that person wear a tuxedo purchased on American Express, smoke cigars purchased on Visa, and drink champagne purchased on the MasterCard. Okay? Now, the problem with that is that an outside observer, someone like Frank Bennett or Aubrey Kauffman coming into the classroom, would probably just notice the one person in the tuxedo. And that has been a problem in the legislation. I like to call it, again, the battle between the t-shirts and the tuxedos. So in the rest of my paper, or the rest of my talk, if you hear me talking about tuxedos and t-shirts, you know what I'm getting at. What C-22 tries to do for the t-shirts in the crowd is it allows those individuals to go through the insolvency, either a bankruptcy or a proposal, with a minimum of hassle and red tape. And they'll even allow these people to get some counseling, which will, at the end, hopefully put them in a situation where they'll be able to avoid financial difficulty in the future. With regard to the tuxedos, well, on the one hand, it doesn't make it any easier for them to go bankrupt. And I think as we work through the paper, you'll see that it may make it even more difficult, or it may make it more difficult for them to get out of the process without suffering significant financial hardship. Now, I'd like to deal with the case study. We'll talk about consumer bankruptcy first. Maybe I should back up for just a second. The agenda talk calls this discussion consumer reorganizations and bankruptcy. Well, there is no such term in the Act as consumer reorganizations. There is no such term in the Act consumer bankruptcy. What I'm talking about here is really the issues in the bill which deal with the consumer area, which I've been able to pick out. It's easy when you talk about the consumer proposal section because there is a whole new section just dealing with that part. It starts at section 66.1 and .11 in the bill. And if you're trying to keep up with that no-name section that's in the back of your handout, you look under clause 89 for any changes that relate to the consumer proposal section. Anyway, consumer bankruptcies. Another bit of terminology problem here is that if you wish, you can substitute personal bankruptcy for consumer bankruptcy. It's up to you. I use the term consumer bankruptcy because in any of the statistics that my department publishes, you'll see that we use the term consumer bankruptcies. What we mean there generally is that these are individuals who have a majority of their debts of a non-business nature. Now, your organizer this morning told me or promised me that there would be an overhead projector here and a screen, but it has not arrived as of yet.
It's there.
It's there. Okay. Well, we'll try to work through it without that. Have you all found my paper? It's probably the thinnest paper in the handout. If you want to turn to the cast of characters, just to make sure we're all on side here. What I'm basically going to try to do in this case is outline for you what happens now in both a consumer bankruptcy and a proposal, and contrast that with what will happen when this bill is in effect, hopefully in a few months. Okay? As you can see, the cast of characters, we got the lawyer at the top, obviously. Will Tarham is the lawyer. Tarham's partner, Featherum, I guess, is dealing with the O&Y today. The creditor is indignant, of course. The debtor, you can see, is don't want to pay. The trustee is Crimea River. And the creditor is representing a credit union that I've called Holier Than Thou Credit Union. I meant no disrespect there. Basically, it's a reference to the definitive case that deals with credit unions and insolvency in this province. The credit union in that case was, I believe, the Holy Rosary Credit Union, right? Aubrey's smiling. He knows it. Okay. The other issues you can see from that handout on the cast of characters, the basic asset situation, and the debts. It's fairly straightforward. Okay, now if you want to turn to the consumer bankruptcy chart, again, if I had an overhead here, what I would do is cover up the part of the chart that deals with 1992, so you can just refer to 1991. Okay, you all with me so far? Okay. Now, going by the basic facts in the case, you show up for the meeting, you're the only creditor present. I'll just get my pen here. The problem is there's no quorum. Okay? What we're doing then in the bill, and you can see in 1991 you need 3 creditors present or represented by proxy to have a quorum. Working down the basic facts again, you can utilize your wage assignment that you have as a credit union. This will give you 20% of the debtor's net until his discharge. In number 3, under the basic facts, or is it the basic facts or what? Okay, the basic facts. Key issue from the trustee's perspective is that even though your security on the vehicle may be defective, you're in control in 1991. If the trustee doesn't have any money to fight you, he's going to settle. You receive notice that the trustee is going to apply for the debtor's discharge. You oppose the discharge, and you have to go before a judge. Okay, and as John Honsberger alluded to in point 6 of the basic facts, because part of your debt, in your opinion, relates to necessaries of life, after the trustee's been discharged, you go before the court and get an order so that you get paid for your necessaries of life. That's basically a synopsis of the situation as exists now, and most of the key elements there are highlighted in the left-hand column of the chart headed Consumer Bankruptcy. Okay? Now, to contrast that with what will exist in 1992, hopefully. Now, I'll deal with each one of these items I'll take a little bit of time with this. In point 1, this estate would be classified as a summary administration. There's been a change. If you look at the chart again, if you see that it's $5,000 that will, where estates up to $5,000 will be able to be classified as summaries. This is basically a codifying present practice. The quorum issue is significant. It will only take 1 creditor to have a quorum at meetings. What this means is that it'll be easier for you to be an inspector if you wish. It'll be easier for you to substitute trustees if you want. And I think it'll be an attempt at getting creditors more involved. And if you've got one of those debtors that's a tuxedo, and you're the only creditor that's taking an interest, you'll be able to make some noise. Number 3, Revenue Canada's debt for $5,000. This is another issue that I think it affects the tuxedo-type bankrupts. In that, in 1992, this debt will simply be an ordinary claim. No more will creditors show up at the creditors' meeting and be told that there's a huge Revenue Canada debt of $500,000 and therefore they may as well forget about taking any interest in this thing. You will be able to share. And again, this will hopefully get the creditors more involved. Joe's budgeting problems. Okay, we've talked about this. A few people have talked about this morning. Under section 157.1 of the bill, and there's been a change to this too, the slight change that you'll see in the section at the back. Joe will be required to obtain counseling. Now, what we envisioned the counseling to be, if you take a step back to before Joe either goes bankrupt or files a proposal, is that he or she will meet with a trustee and or an administrator. Number 1, the administrator or trustee will go over and give them an assessment of what their situation is and what options are available to them. This will be classified as counseling step number 1. Later on in the process, counseling step number 2 will be to hopefully get the debtors to recognize what their problem is, that, you know, in a lot of cases the problem will simply be that they can't pay their debts. It may be illiteracy, maybe some other deep-seated psychological problems or whatever else, but lots of times there is more to it than simply a financial difficulty. And the hope is that if these debtors can recognize the problem, that they will be able to seek appropriate help. And again, the ultimate aim is to ensure that they do not find themselves in financial difficulty in the future. The issue of the credit cards in point 5, there will be a directive submitted or sent out dealing with credit cards, so there will be some control over that. Now the key one in point 6 about the notice of disallowance of the secured claim, this is a major change, and it's particularly important in these small personal bankruptcies where the trustees generally don't have much money. If you're representing a bank or a credit union in this case, the trustee will be able to disallow your secured claim. And then the onus is on you to take the trustee to court once he's disallowed it. And the other interesting sideline on that is that you'll see, if you look at the chart, that as exists today, it would be a judge who would deal with that issue. But in 1992, it will be the registrar. So I suppose on the one hand, it'll be tougher for you representing creditors, but on the other hand, it'll be easier for you to get the matter dealt with expeditiously before the registrar. Okay, the credit union's wage assignment, will no longer be valid in Ontario. Ontario is the only province in the country that has allowed this to continue. And if you talk to any other creditors involved with consumer bankruptcies, they're always adamant in their dislike of the advantage the credit unions have here. Now that advantage will be taken away. And another key point to remember is that there is a transitional section dealing with this issue, which means that the wage assignment will be invalid for those new bankruptcies taking place after the coming into force date. In point 8, the opposition to the discharge of the debtor issue. As it is right now, oppositions to debtor discharges are heard by a judge. There has been a change in the bill. Registrars will be able to deal with all discharges, whether or not they're opposed. Okay, so we hope that this will achieve quite a high degree of consistency. Again, quicker and easier access. Creditors won't necessarily have to retain legal counsel. Oh, maybe I shouldn't have said that in this group, but there is that possibility. And point 9, the procedure for taxation and discharge of the trustee will be streamlined again. That really doesn't affect too many people in this room, although I see, actually Jerry Friedman is here, another token non-lawyer in the group. In point 10, the issue of necessaries of life, John Honsberger talked about this extensively. Necessaries of life, that section will be wiped out. Another interesting little wrinkle that wasn't noted is that there is no transitional provision for this section, which means that as of the coming into force date, if the debtor if you have not obtained your judgment against the debtor for necessaries of life by the time of the coming into force of this thing, you'll be out of luck. So you might want to make note of that. Okay, that's consumer bankruptcies. Basically, the one other change that you might want to think about is there's a change in Section 68 regarding payment orders for salary of debtors. There's a somewhat broader application there. You'll be able to go after individuals who have commission income and that kind of thing with a much greater chance of success. Okay, that's consumer bankruptcy. Consumer proposals. As I mentioned before, there's a whole new section dealing with consumer proposals. You can see in the preamble to this section, they talk about what's available right now. We're looking at some considerable numbers here of people who may be interested. John Honsberger alerted us to the issue of Part 10 being available in some provinces. Part 10 is not available in Ontario, but there is the Ontario Credit Counseling Organization, which, as you may have heard, has been faced with some severe financial cutbacks by the government. But they will still be able to do their informal proposals. The question remains, though, which debtors would use an informal proposal mechanism when there will be a formal proposal mechanism available to them. The individuals who administer consumer proposals will be classified, will be called administrators. Administrators may be either a trustee in bankruptcy or someone designated as administrator by George Redling. The issue of who will we appoint or designate as administrators has not been settled fully as of yet, although we anticipate that it will probably be, we'll probably make it open to the provinces. So we may be faced with an issue of competition of private trustees versus provincial authorities. Now, having said that, the rest of the consumer proposal section, I like to think of, if you use the catchphrase that I've put in my paper, a whole lot of deeming going on, which is really what it's all about. If the debtor makes a decent proposal, everything throughout will just deem to have occurred. There's no requirement for a meeting of creditors. There's no requirement for court approval. As long as the person's making the payments, it'll just go through extremely smoothly, and there'll be nothing formal in the process, except at the end, the debtor will be given a certificate of performance saying that this thing was successful. So those are some general comments. Now let's just deal with the particular case study issues. If you want to turn to that chart that deals with consumer proposals, it gets at the key differences again. Again, in consumer proposals, some of the important issues are that counseling will be a requirement. The administrator will have to provide for counseling of the debtor. And I suppose the key thing that you should remember as lawyers is that there is no such thing as an automatic bankruptcy following in any connection with a consumer proposal. If the consumer proposal fails, if it's annulled either by the court or simply by way of the debtor not making their payments for 3 months, the consumer proposal is annulled, but there is no bankruptcy. Okay? But what this means is that the debtor is basically back on the street. You can take up any remedies you had before against the debtor. With regard to, let's sort of take a step back a second. If we assume this is one of our tuxedo cases who's filing the consumer proposal, there is provision for a meeting of creditors if 25% of the creditors request it, or if the official receiver deems it necessary to have a meeting. The way I see it is that if any creditor were to contact me and say, look, there's all kinds of problems with this thing, it might make sense to have a meeting, I can't see any reason why we would not accede to that request. What we anticipate, though, is that there will be a requirement for very few meetings of creditors. As far as court review, again, it's not mandatory. However, if any interested party wants the court to review the proposal, that's provided for in this section. The wage assignment issue, again, it's the same as in bankruptcy. Wage assignments will no longer be, of credit unions will no longer be valid after the proposal. And the same provisions that exist in the commercial proposals regarding public utilities also exist in consumer proposals, although it appears to be stretched a bit as to why those sections were taken over exactly into the consumer proposal section. There's a couple of other interesting little issues that you might want to make note of that aren't in my paper. First of all, with regard to the issue of preferences and settlements, under the commercial proposal sections, trustees there will be able to go after preferences and settlements in the same way as they can now in bankruptcies. However, under consumer proposals, they will not be able to go after preferences and settlements. Okay? However, the safeguard there is that if the consumer proposal is annulled, okay, either by the court or automatically when the debtor misses 3 months' payments, and then subsequently if that debtor files an assignment in bankruptcy, okay, the assignment in bankruptcy will go back to the date of the original filing of the consumer proposal, and you will then be able to go after that debtor for any preferences and settlements at that point. So there is a checks and balances in that system. Okay. Actually, those are basically the points that I wanted to make today. The paper is very brief, as I've said. I will be around for the rest of the day. As you can well imagine, I'm not in any hurry to get back to Ottawa. So if you have any questions regarding the consumer areas, feel free to grab me at some point, or I'm prepared to take questions now for a few moments.
I have one question to ask. The ability of the trustee in a consumer proposal to have access to remuneration of of a doctor, for example, as I understand it, is different than presently exists, and may impact on certain professionals who did not receive wages, and therefore were able to skirt around the present provisions of the Bankruptcy Act. The classic example being doctors. What changes are there?
Well, if you're talking about the consumer side, number one, as far as consumer proposals go, most doctors wouldn't be able to file as under the consumer
I'm
proposal
not talking
section.
about a proposal. I'm talking about just the bankruptcy.
Under the bankruptcy side.
Yeah.
Well, I think the other change that's, I believe, in the amendments is that assignments of wages or given to banks as receivables, or assignments of receivables given by professionals will no longer be valid after bankruptcy. That's in, again, that no-name section that you'll find in the back of your handout.
Yes. Anybody else? Yes.
What's the impact on secured creditors in the consumer proposal?
Good point. Secured creditors are not affected by consumer proposals. That's another major change from, or a major difference against the commercial proposal section. Secured creditors will still be able to deal with their security as they see fit. But again, consumer proposals are meant for Joe Average. That's really what we're trying to get at. The limit on the amount of debts that Joe Average can have of $75,000, there's an escape clause there, and that it's or as prescribed. Okay, and over the next 3 years, if we see that limit should be increased, well, I think we'll be quite willing to do that, depending on what shakes out in the next 3 years.
Any further questions?
Okay.
I want to thank you very much. I think that these provisions, particularly in the hard times that we find ourselves in, are going to be particularly useful to the average Joe. Hopefully, more T-shirts will use it than tuxedos, and if there are too many tuxedos out there, we'll try and get to them. We are going to stand adjourned until 1:30. I want to admonish everybody, though. I don't know if you remember the last time that you sat in these seats, but I know that when I did and we hit lunchtime, it would be straight to the squash courts, and then I would move on to my diet of Gilligan's Island, Beverly Hillbillies, and Mary Tyler Moore before I ever considered reading anything that was handed out in these halls. Don't follow that pattern, please. Please be back promptly for 1:30. Thank you.